there wasn't a motivation to try to hurt the representation with Mr. Baez or Ms. Anthony. Your Honor needs to know, even if not us, who filed the complaint, if it is true, and then if it is true, there has to be some type of hearing about the motivation to file it. Whether these prosecutors knew that it was being filed, why was it being filed, what was discussed, was there any motivation? Now, of course, as Ms. Jane Burdick notes, we can't cite the specific factual support because it's anonymous. That's why we're here. But in order to ensure that Ms. Anthony gets proper representation, that there wasn't a motive to interfere, Your Honor has to do more investigation. And I would point to Your Honor the cases on this. The prosecution did pick a case out of a citation out of the Michael Hayes case in 2008, where they cited the Higgins case, quoting Clausel. But what you have to look through is to the federal court cases here, Your Honor, and that is the U.S. Supreme Court. And the U.S. Supreme Court says if there is an unintentional interference with counsel rights, then it could be harmless error. Then we may have to show prejudice. But if it is an intentional interference, an intentional issue to cause harm, then we do not have to show any prejudice. Your Honor then has to fashion some remedy. And those cases are, and I would point to Glasser versus United States, 315 U.S. 60, 1942. These are old Hornbook cases because it's so clear. Black versus United States, 385 U.S. 26, 1966. And a number of other cases which say that while usually there's a balancing test, if there's a judicially created exclusionary rules, if there is a right to interfere with a Sixth Amendment right to counsel, there is no balancing test. And the United States Supreme Court went on to say it is true that where there is gross misconduct on the part of the government, no prejudice need be shown, and gross misconduct can be an intentional interference with Sixth Amendment rights. If there was no purposeful intrusion, the United States Supreme Court said in Weatherford versus Bursey, 429 U.S. 545, 1977, then counsel must show the realistic possibility of prejudice. But if there was an intentional intrusion, then the burden shifts, and they have to show, they may have to show as to why they did it and that they didn't have an ill motive.
Okay, 30 seconds to wrap up.
I am almost wrapping up. This issue, in terms of prosecutorial intrusion, just came to light in a Broward County case the courts gave judicial notice of, where a judge has halted a murder trial when the prosecutors actually reviewed tapes between an attorney, a client-attorney relationship, even though they were investigating a crime. And in light of the fact, Your Honor, that we have seen that without some type of judicial investigation by your part, at least hold this in abeyance if you don't feel you have enough today until you have those questions answered for you, so that whatever happens here is protected on both sides. Both the prosecution's right to have a fair trial if they get a conviction that it's not overturned, both our right to make sure that our client is represented properly under the Sixth Amendment. And we thank you very much for your time, Your Honor.
Thank you. Who's going to respond?
Respond. Judge, I had, in response to their motion, filed a motion to strike it. I believe that the court had received that yesterday afternoon, and I sent it to counsel as well at the same time, citing the controlling cases in the state of Florida. Before we even get to that point, I would ask that the court strike their motion as providing insufficient factual support. Counsel's assertions of what was reported in the media certainly is double or triple hearsay. Her referencing a letter or a name of an individual that doesn't appear in their pleadings certainly puts us at some disadvantage, because I've never even heard of this person that she is now directly citing as some sort of factual support.
The motion's light on the facts, I admit. Why don't you go ahead and respond, though? Give me your thoughts.
One of the things that they didn't address was how the state of Florida, through someone's filing of a bar complaint against Mr. Baez, has interfered with Ms. Anthony's Sixth Amendment right to counsel. If they are suggesting that a bar complaint is embarrassing to Mr. Baez or time-consuming or requires him to hire a lawyer or to take other action, that inures to him, not to Ms. Anthony per se. So what the case law in this state has discussed is whether or not there's actual prejudice of some sort to Ms. Anthony. They haven't even alleged actual prejudice. What they're saying is perhaps they have now interfered with her Sixth Amendment rights without providing any support for that position. Additionally, as it relates to a motion to disqualify, and as cited in my response, it doesn't necessarily disqualify the prosecutors on a case if there's some member of our office, since we're not a firm, that has filed a complaint. So there's also no specific prejudice that is either alleged or proven for the court. We would ask the court, since this motion is based exclusively on reports of the media, to strike it, and if they want to refile, if they feel that they have some factual or legal support for it, they can do so at that time.
All right, let me give you 30 seconds to respond.
Your Honor,
Just
it
briefly,
doesn't have to be any actual prejudice. It's the motivation was to interfere, and that's the issue here, which we have to trust you to have ask the prosecutors, was it true that someone from their office filed the complaint, and who was it? If they say yes, it was true, who was it? Then Your Honor has to go further to find out what the motivation is, because prejudice presumed if indeed the motivation is an ill motive to interfere with the rights, as opposed to reporting something that they felt was viable.
Anything else?
Not on that point.
Okay. All right, on the emergency motion to recuse, really the issue here is whether or not Ms. Anthony's Sixth Amendment right to counsel has been affected. And just based on what I've heard here, I view this as a Florida bar matter, not something I need to be knee-deep in. And I don't think Ms. Anthony's right to counsel has been affected. I don't see any actual prejudice. Again, the factual basis for the motion is, as I said, thin, and it's denied. So the motion to recuse is denied.